Hello, this is the next in the series of presentations on the Jackson Reforms 2013, which came into force on the 1st of April 2013, and this one is on Part 36, Offers to Settle. Now, Part 36 is of considerable importance in tactical litigation, and so the reforms are of particular interest to practitioners. These reforms to Part 36 flow from Sir Rupert Jackson's view that the prizes available to claimants for making successful Part 36 offer are insufficiently generous. Now, on the face of it, that's not so, because the prizes available to claimants are more extensive than those available to defendants. But Sir Rupert Jackson's point is that the reality is otherwise. As briefly discussed in the first of these presentations, the prize available to a defendant for making a successful Part 36 offer, that is to say, an offer which the claimant fails to beat at trial, is that the claimant will have to pay the defendant's costs on the standard basis, plus interest on those costs, running from the last date on which the offer could have been accepted. On the other hand, the prizes available to a claimant for making a successful Part 36 offer, that is, an offer which the claimant equals or beats at trial, are threefold. First, costs on the indemnity basis from the last date on which the offer could have been accepted. Second, enhanced interest on the principal sum recovered. And third, enhanced interest on the costs. Now, the reason why Sir Rupert Jackson says that the claimant's prizes have to be improved further is this. In order to incentivise a claimant to make a Part 36 offer, the prize has to be substantially better for the claimant than the result which the claimant can expect to receive at trial as a result of success. The general rule as to costs is that the unsuccessful party has to pay the successful party's costs. Therefore, ignoring Part 36 offers the normal outcome of a claim in which the claimant makes some recovery at trial is that the defendant will have to pay the claimant's costs on the standard basis. An incentive to make it attractive for a claimant to make a Part 36 offer, which involves allowing a discount on the claim, has to be measured by the level of improvement from that base position. Consequently, Sir Rupert Jackson recommended a further prize for successful claimants' Part 36 offers, that is, an additional 10% added onto the debt or damages awarded. The necessary change has been made to the primary legislation, Section 55 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. Now, in two ministerial statements made in May 2012 and July 2012, the Ministry of Justice published further details of the proposals, and we now, of course, have the rules themselves. In outline, first of all, the amount of the enhanced award. That enhancement is to be an additional amount paid by a defendant who doesn't accept a claimant's offer to settle, where the court gives judgment for the claimant that is at least as advantageous as an offer to settle the claim. This additional prize is 10% of the money awarded, and it can be a debt or damages if a money sum is awarded. Where the claim is not for a money sum, the sanction will be an additional 10% on top of costs. Now, in mixed money and non-money claims, then the sanction will be 10% of the damages element of the claim, and there will be no enhancement on the costs over and above the normal Part 36 effect of a successful claimant's offer. In very large claims, there is to be a tapering system. Now, the sanction will be applied once only. For instance, in the case of split trials, that may be relevant. Now, some points need to be made about the relationship between Part 36 and the qualified one-way cost shifting recommended by Sir Rupert Jackson. Now, Sir Rupert's proposals for qualified one-way cost shifting in personal injury cases work as follows. If a claimant has properly conducted their case in a personal injury claim, they won't have to pay a sum towards the defendant's costs if the claim fails. It's otherwise if the defendant's defence fails and the claimant is successful, because in those circumstances the defendant will have to pay the claimant's costs. So there's no longer symmetry between the positions of the two parties. Now, qualified one-way cost shifting is available for all claimants in personal injury cases, whatever their means. There's no financial test to determine eligibility. Claimants who lose do not have to contribute towards defendants' costs so long as they've behaved appropriately. There's no question of a minimum payment having to be made by a claimant in those circumstances, as had been recommended earlier on. Claims that are discontinued during the proceedings, so long as they're not fraudulent, will not result in the claimant having to make a payment towards the defendant's costs. And in appeal proceedings, the requirement for permission to appeal controls unmeritorious appeals. So there's no requirement for a cost sanction as well. Now, qualified one-way cost protection is lost in 3 sets of circumstances, and the last of them is relevant for current purposes as we're looking at Part 36. The 3 circumstances are, first, where the claimant's found on the balance of probabilities to have acted fraudulently. Secondly, where the case has been struck out because it discloses no reasonable cause of action or constitutes an abuse of process. Thirdly, and this is the one relevant to Part 36, where the claimant has failed to beat a defendant's Part 36 offer to settle. Now, the next knock-on consequence we're going to look at is the relationship between the Part 36 reforms and Simmons and Castle. Now, in Simmons and Castle, the Court of Appeal sought to assist in the implementation of the Jackson reforms by laying down judicial guidelines for the assessment of general damages, which will be awarded after the 1st of April 2013. Now, the idea is that there will be a general, across-the-board, 10% increase in general damages. This was regarded by the Court of Appeal as part and parcel of Sir Rupert Jackson's plan for abolishing the recoverability of success uplifts and premiums on after-the-event insurance policies by the successful party against the unsuccessful party. Those 2 things were recoverable before the 1st of April 2013, but recoverability of those 2 things became impossible after respective proceedings commenced after the 1st of April 2013. Now, the fact that a claimant with a conditional fee agreement and after-the-event insurance would have to pay the uplift and premium, respectively, even if successful, out of the damages awarded, would have meant that claimants would generally be worse off, since damages are intended to be compensatory and not more. If they lost part of those damages, then they would be worse off as a result of the reforms. Hence, Sir Rupert Jackson's proposal that there should be a general increase in damages, and that is what the Court of Appeal sought to facilitate in Castle and Simmons. Now, putting this element of the reforms into place by judicial legislation in the manner adopted by the Court of Appeal was, it must be said, an eccentric way to proceed, even if it was the only way in which we could operate in a common law system. The fact is that the very eminent Court of Appeal in question heard no argument on these questions, and so unsurprisingly they didn't think through all of the implications of their decision that there should be an across-the-board 10% increase in general damages. And this resulted in the intervention of the Association of British Insurers and a revised judgment dealing with the overlooked need for proper transitional arrangements to prevent claimants whose CFA uplifts and ATE premiums are recoverable, because they had issued their proceedings before the 1st of April 2013, from getting the damages uplift as well, an unwarranted windfall. Now, it appears that the 10% uplift to be awarded as a result of the revised Part 36 rules will be on top of the Simmons and Castle 10% uplift, and that will therefore result in a grossing up effect. And that's all on Part 36. Thank you very much.